What's up everyone, my name is NINAAD and I'm a legal intern at LEXIS and Company and I'm also a student of the Maharashtra National Law University, Mumbai. Today we will be talking in brief about the legal aspect of the pandemic that has been gripping the world for the last 2 years, that is COVID-19. According to the WHO, a pandemic involves a worldwide spread of a new disease, while an epidemic, on the other hand, remains limited to a city, a region, or let's say a country. The pandemic spreads beyond national borders and can also possibly spread worldwide. Now, a similar situation has arisen today. Since the end of 2019, the world has been grappling with the coronavirus, or otherwise known as COVID 19, which has spread rapidly and has escalated to the scale of a pandemic in no time. In such a scenario, a strong foundational action structure seems to be the most important resource that any entity can possess. In our world, the law plays this role. Thus, having witnessed so many precedents, namely the Spanish flu, the bubonic plague, etc., a detailed and thought out legal action plan becomes a prerequisite for any nation or any state to function efficiently, irrespective of the times. In the Indian context, this role is played by the Epidemic Act of 1897. It was primarily enacted by the British during the colonial times to curb the spread of the bubonic plague in India. The various sections of this act, notably section 2, 3, and 4, bestow the central and state governments of the country with the power to create a lockdown like situation that we have witnessed in the past year. But the effect of this act has only been lockdown like, and a lockdown is not necessarily the exact same. Although, on the face of it, it seems appropriately placed, but this legislation is more than 120 years old. Its only purpose was to counter an epidemic and not a pandemic. So there's a difference. Um, the scale of operation of this act was very, very limited, and the effect on the population was also supposed to be very limited as well. Hence, it does not have a very elaborate plan of action. In this scenario, the only available alternative is the Disaster Management Act of 2005, which is currently being used, treating the pandemic like a disaster. Now, all the lockdowns that have we have witnessed in the past year have only been possible due to this act, read with entry 23 of the concurrent list of the Constitution of India, which is titled Social Security and Social Insurance. Entry 29 of the same, titled Prevention of the Extension from one state to another of infectious or contagious diseases or pests affecting men, animals, or plants, can also be used for these specific legislative actions. But even the DMA, as is being witnessed by the world, failed to keep up with the destructive pace of the virus. There have been various internal infrastructural problems and evident lack of management skills within the disaster management authority that have resulted in the current situation being as it is. As it is, the government needs to fill the plot holes in what has the actual potential of becoming a properly effective response plan for any sort of disaster or even a pandemic. Hence, after witnessing the after effects of the COVID 19 pandemic, it is evident that the government needs to rethink its overall health policy and bring in new legislations to effectively tackle the present and arguably all future pandemics and disasters. That is all for the video. I hope you learned something from it. If you did, please do like, share, and subscribe. Please comment down below any questions or suggestions that you might have. We'll get back to you as soon as possible. And that's all. Thanks for watching, and I hope you have a good one.